Hello, good morning. My name is Lydia and welcome to my channel. Today I'd like to talk about termination, employment termination, and the grounds for termination. So, what is termination? Termination is a situation whereby either the employee or employer decides that they no longer want to continue with their employment relationship. For example, in terms of the employee, maybe this person no longer feels comfortable at their area of employment. Maybe they've gotten a better opportunity somewhere and they like to leave this one and proceed. For an employer, probably it's because of gross misconduct, or maybe they can no longer financially sustain this employee. So according to the Employment Act of Kenya, Section 35, Clause 1, lawful termination of employment under common law includes termination of employment by agreement. What do I mean by termination of employment by agreement? This is a situation whereby the employer and the employee agree to bring the contract of employment to an end in accordance with an agreement. They have to put an agreement down that stipulates that the employment contract or the contract of them engaging in services with each other has lapsed. For example, when someone is an internship, so when the training period expires, the contract will obviously have come to an end. See, when you take an intern, you've taken an intern for maybe 3 months. So at the lapse of the 3 months, that contract has ended. Yeah. Or maybe when you're employed and the employment is on the basis of contract. It's a contractual employment. So for example, your contract is for 2 years. And while it lapses, your employer has not brought out the desire to renew it. So at the final date of the contract, for example, if it was supposed to end on 6th of August, so on 6th of August, that contract automatically ends. So your contract of employment has been terminated. It has ended. So there's also another version where it's automatic termination. In terms, for example, I have a job, I've given it to someone. Unfortunately, this person passes on, the person dies. So that automatically terminates that contract because the person to which was bound by that contract is no longer in existence. Yeah. Or maybe I've given you a contract, but you see, like for example, with the NGOs, mostly they depend on donor funding. So let's say they were expecting some money and then the money doesn't come through. Of course, they cannot keep you if they cannot pay you. So that can be another reason as to why a contract is terminated. A second version is by resignation of the employee. That is whereby I was telling you, for example, when you get a better opportunity, you no longer want to keep this one, or you just want to move on to the next step of your life, for whatever reason, but you write a resignation letter to your employer. Or maybe because your employer has actually breached your initial agreement, so you decide, no, I can no longer work with this person. So there's also a version that, the third version will be a termination of employment by the employer. An employer may also terminate your contract, but for an employer, for whatever reason, they're terminating it. But for whatever reason it is that they're terminating it, they have to be compliant with the law. They have to comply with the provisions of the law regarding termination. Even you, when you're issuing a resignation, of course you have to be compliant, dependent on your terms of service. For example, maybe you'll need to give 1 month in lieu of notice, that is the standard, or pay your employer for that period. So on what grounds can a contract of employment be terminated by the employer? That is the basis I'm interested in addressing today, because a lot of people are passing through different scenarios trying to understand, or maybe to understand whether the termination was legal. So the first scenario whereby your employer can terminate your contract is by mutual agreement. Now, the other reason a contract can be terminated, it's by the employer when the employee dies before the duration of the contract lapses. That is something I had earlier talked about. Just the previous one, just to go a little bit behind here, when the contract is terminated by mutual agreement, this is covered by the Industrial Training Act, Section 13, Clause 1A. You could go maybe research on it, find out more. And then by the employer, if the worker is found by medical examination to be unfit for employment due to sickness or an accident, the employee becomes unable to carry out the purpose for which he was initially employed. So that can lead to the termination of the contract. For example, you work in a company, you job, let's say, maybe for example, you are, what job can I use? Let's say you're a surgeon. You need both hands and you need the stability of your hand. Unfortunately, you're involved in a road accident and you lose your arms. So given that you can no longer perform as a surgeon, that can lead to the termination of your contract. Or maybe whatever you're doing, for whatever reason, it needs some expertise that you're no longer capable of doing because of ailments or something like that. So that means you will no longer be able to perform the duty for which you are employed. That leads to the termination of the said contract. Now, there's also the final reason, which a lot of people find themselves victim to. The employer can terminate your contract on the basis of misconduct. And when you're talking about misconduct, this is basically covered by the Employment Act on Section 44 of the Employment Act, Clause 3. Section 44, Clause 3. So, what should an employer do when he or she wants to terminate a contract? First of all, you're supposed to be given a period of notice. For example, what does your contract as an employee say about your notice period? So, the notice period. For example, if your contract say that your notice period is supposed to be 1 month, then your employer is actually supposed to send you a letter of termination that gives you a notice period of that 1 month. Yeah, the notice, remember, has to be in writing. Someone cannot just wake up today and tell you, you know what, this is your last working month, and there's nothing in writing in that case. If the said employee does not understand the notice, yeah, the employer, your current employer, is responsible to ensure that the notice is explained orally to you in a language that you understand. So you have to understand your termination notice. 1. If you are employed on a weekly pay or 2-week basis, the notice period shall be 1 week or 2 weeks, respectively. If you're employed on monthly basis, then your notice period shall be 28 days in writing, or payment of 1 month in lieu of notice. So they give you an extra month's pay if you will not stay there any longer. Yeah. So there's always this question that can your employer terminate you immediately without allowing you to work during the notice period? And that is a yes. But you see, for them to do that, that is when the 1 month in lieu of notice applies. The employer will be required to pay you the amount that is equivalent to your 1 month salary or the notice period given. That is, it's normally referred to as payment in lieu of notice. So on that one, that specific aspect is tackled by Section 36 and Section 38 of the Employment Act. Now, when it comes to, so one might ask, what if you've accumulated leave days and you have not used them? Yeah. In the case you've accrued leave days, standard given in Kenya, you're entitled to 21 leave days in a year. So let's say you've finished this year, maybe it's November, and in the entire year you've probably used maybe 3 or 4 or 5 days. Yeah. So what happens to the remaining days that you had accrued during the year? What is supposed to happen? Now, the employer shall pay you on a pro rata basis an amount in cash for the accrued annual leave in which the employee is entitled, provided that it is not taken later than 6 months after the leave cycle ended, or 12 months at the end of the cycle. So generally, what I'm trying to say is that if you've accrued 10 days that you've not used, your employer is supposed to pay you for the 10 days. In essence, basically, actually, they're supposed to pay you your standard daily rate for the 10 days. If your standard daily rate is 1,000 shillings, then you're supposed to receive 10,000 for the accrued days. Yeah. Can your employer terminate you without notice? If he pays you an amount equal to the accrued remuneration which you would have earned during the same period. Another thing you're entitled to is a certificate of service. That is your entitlement. It is not a favor someone is doing you. As long as they have terminated your employment, they're supposed to issue you with a certificate of service. It is a mandatory requirement in Kenya, regardless of the reason they're terminating you. Unless you're employed for less than a month, less than 4 weeks. But as long as your employment was for about 4 weeks, whether you did whatever it is, you're still entitled to your certificate of service. Now, this is another thing where there is bad blood between the employer and you. Can they use that as a reason to terminate you? No. No, they cannot use whatever is going on between you two to terminate you. There are reasons that are actually stipulated that can be reasons for termination. The first reason is misconduct. This is where your behavior is unbecoming of your job. The second reason is physical incapacity. For example, you drink so much, you come to work, you're unable to perform, that can result into your termination. The third reason is poor performance. When your performance is consistently poor, that can be a reason for termination. And then operational requirements for the employer. For example, they need to downsize, so they need to retrain some people. That can also be a reason to terminate. Now, when it comes to poor performance, another thing that they need to really look in, they should have actually done performance evaluation. You should have been told your areas of weaknesses. You should have been given room for improvement and training if you needed it. And if you persistently do not perform, that is the only way they can use poor performance as a reason for termination. Now, there are certain scenarios whereby all these are applicable. Maybe it's misconduct, maybe it's poor performance, whatever it is. But you see, in Kenya, for termination to occur, it has to be both. It has to be procedurally right and anyway. So, what amounts to fair termination? In order for there to have been fair termination, for your termination to have been done correctly, and you deserved it in the eyes of the law, it has to be substantively and procedurally right. That is the word I was looking for. Both in substance and in procedure. It has to have been termed as fair. The employer needs to have a valid and fair reason for termination. That is one. The reason has to be valid. Secondly, the reason has to be fair. Apart from being valid reason, yeah, the employer must follow fair procedures for termination, the right procedures as provided under the Employment Act, Section 45, Clause 2, and Section 46. In any form of termination, the employer is required to prove that the reason for the termination, otherwise, it will be termed as unfair. Otherwise, if he cannot prove the reasons for termination, your termination will be termed as unfair. The procedure of terminations are different depending on the reason for termination, but they have to have a common item, the right of an employee, your right to be heard before termination decision is taken. You have to be heard, you have to give your side of the story before a termination decision is taken against you. If you did not have a right to express yourself, then given the law of Kenya will consider this as unfair termination. So, what happens when maybe you are caught red-handed committing a serious misconduct? For example, you are caught stealing. Yeah, red-handed. Someone caught you stealing, or there is a CCTV showing that you actually stole. What happens? Can you just be told that is the door, out you go? No, not in Kenya. It doesn't matter how serious an offense you committed, and it doesn't matter how much evidence is available. The law requires that the procedures outlined are followed. The law strictly stipulates that you have, as an employer, you have to follow the procedures stated out. If you fail to follow the procedure, this will amount to summary dismissal. Which means you, as an employee, you are terminated without being given an opportunity to defend yourself before a disciplinary committee. It's another thing, a disciplinary committee has to be formed. So, if you are dismissed without being given an opportunity to defend yourself, it is automatically unfair termination. Doesn't matter how much red-handed you're caught doing anything, it amounts to unfair termination. Now, what if an employee is facing criminal charges? Can you just terminate this person? The answer is no. No one can terminate or take a disciplinary action against an employee who is facing the same charges before a court of law, unless the two charges are different or do not arise from the same cause of action. You cannot be having a court case on the fact that you stole from your company, and then a disciplinary at the same time is also being raised against you in the company for the same reason. This amounts to something which is called double jeopardy in law. You cannot be tried twice for the same offense. Legally unacceptable. So, yeah, I do hope you understand what is expected of you. Always ensure you also have a right to actually bring in a witness. So when you call, like you're given an opportunity, actually the right procedure for misconduct or wherever it is, there should be a rehearing first. First of all, you're given a show cause letter. A show cause letter basically actually requests you to outline why you are accused of A, B, C, D, blah, 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 Z. You should entail why disciplinary action should not be taken against you. To which you respond, yeah? If your response actually answers the issues that were raised satisfactorily, then there is no need to proceed beyond that. But if your answers do not satisfy the need, the whatever, are not satisfactory, then an investigation into the matter is also introduced. Whatever results of the investigation actually is what will lead to the show cause. If you can explain them, good. If you cannot, then a disciplinary is held. What happens in this disciplinary? So the first things first, you're given an opportunity. First of all, you're given time to prepare for the hearing. You're also given an opportunity to present your evidence. You're also given an opportunity to bring a witness, as long as it's not lawyers. Most companies don't go for lawyers, but you can bring a colleague, you can bring your trade union representative, any person you feel will be better suited to help you argue your case. And then the disciplinary is held. There has to be a disciplinary committee, someone who's partial, the person who's accusing you, the entire technicality of that. Only and only after the disciplinary you've presented your case, your accusers presented their case, whatever you had to present, you've been given an opportunity to actually do it. Only then can the evidence be assessed and a decision made. A decision can only be made on the content of the disciplinary, not before. So that is when you know what is going to transpire. Are you in for a warning letter? Are you in for termination? Whatever it is that your fate will be, that is the point that you actually get to understand. I hope I've been of help to someone. Thank you for watching. Do have a lovely day. Ciao.